Halo, Assalamualaikum warahmatullahi wabarakatuh. I'm Muhamad Satria Prakasa from Faculty of Law Pasundan University, and here I want to read the text about the business law. Business law deals with the creation of the businesses and the issues that arise as exciting businesses interact with the public, other companies, and the government. This area of the law draws on a variety of legal disciplines, including tax law, intellectual property, real estate, sales, employment law, bankruptcy, and others. Business law provides rules and guidance for companies to follow before dispute occur. Businesses can be formed as corporation, limited liability companies, or partnership and other entities. In practice, business law is closely connected with the other laws such as securities law, antitrust law, bankruptcy, labor and employment law, and environmental law. Most business enterprises are organized in one of three ways: as a sole proprietorship, as a partnership, or as corporation. Each business organization shares some common aspect with others, but differs in method of ownership, the degree of personal liability of the investor for the enterprise, depth, and the complexity of structure. A sole proprietorship is a business enterprise owned solely by one individual. It is the most elementary organizational form of business and simplest and less expensive to form and operate. Local accountants or attorneys in business for themselves or small retail shop are likely to be sole proprietorship. The formation, operation, and management of sole proprietorship are generally simple. It is not necessary to file any documents with any governmental office other than local requirements. Then the owner register the name of the business to prevent fraud. This registration will be notify the public. For example, the Rusulov is doing business as Rusulov El Sakari. A partnership is an association of two or more persons to carry on a business to profit as co-owners. There are two kinds of the partnership, general and limited. An agreement to operate as partnership can be written, but unlike a corporation or limited partnership, there is no requirement that any documents be filed with any government authority. The agreement may even be oral, and partnership agreement may even be implied from conduct despite a written agreement to the contrary. Like the sole proprietor, partner in a general partnership are exposed to unlimited liability, and the partnership doesn't have to pay income tax separated from its owners. Instead, the income or loss of the business is reported and the partner. Personal individual tax returns. The choice of partnership form rather than sole proprietorship is chosen over corporation to avoid the complexities involved in forming and running a corporation. A limited partnership has both general and limited partner. It differs from legal partnership in the fact that the limited partners are not subject to unlimited liability for the debts of the business and risks only the loss of their initial capital contribution to the partnership. Correspondingly, limited partnership have the little control of the running of the business, which is run by general partner of partners. Okay, now about contract law. This text deals with the sum of the main features of contract law. Whenever we buy goods and services, we enter into a contractual relationship. Contract law deals with the promise that create legal rights. In most legal systems, a contract is formed when one party makes an offer that is accepted by the other party. Some legal systems require more. For example, that the parties give each other or promise to give each other something of value. In common law system, this promise is known as consideration in the system, and one side promise to do something does not lead to the formation of an enforceable contract, as is like consideration. When the contract is negotiated, the offer and acceptance must match each other in order for the contract to be binding. This means that one party must accept exactly what the other party has offered. If the offer and acceptance don't match each other, then the law says that the second party has made a counter-offer. Further, to be a valid contract, the parties must agree on the essential terms. These include the price and the subject matter of the contract. Contract may be made in writing or by spoken word. If the parties make a contract by spoken word, it is called an oral contract. In some jurisdictions, certain special types of contract must be in writing or they are not valid. Contract give the both parties right and obligation. Rights are sometimes positive, which a party wants to get form a contract. Obligation are something that a party has to do or give up to get this right. When a party does not do what it is required to do under a contract, the party is said to have breached the contract. The other party may file a lawsuit against the breaching party for breach of contract. The non-breaching party may try to get a court to award the max for the breach. The max refers to money that the court ordered to breaching party to pay to the non-breaching party in compensation. Other remedies include specification performance, where a court ordered to breaching party to perform the contract. A party may want to transfer its rights under a contract to another party. This is called assignment. When a party assigns its rights under the contract to another party, the assigning party is called the assigner, and the party who gets the rights is called the assignee. Okay, that's all from me, and Assalamualaikum warahmatullahi wabarakatuh.